Okay, hi. Thanks, everybody. My name's Jacobsberg. I'm a director at Flaxman's Attorneys in the corporate and commercial department. And what we're going to be doing today is just a general oversight of the very basic legal requirements when you are establishing and running a smaller business. Some of what I say may be things that everybody knows or many of you know already, so please forgive me if it is very basic. If you do want to go into further depth, as I say, please feel free to put questions up and we'll deal with them. So I've tried to go in the order that you're likely to encounter things. Some of these things are ongoing issues that you're going to encounter. Some of the things will be issues that you'll have to deal with when you're setting up and establishing the business. I'll deal with those first. So the first thing that we encountered is deciding what form your business is going to take. There are various forms, and some of them are more or less suitable depending on the size of your business, the number of people involved, how you're going to finance the business, and so on. So the simplest and form is a sole proprietor, which is, as it indicates, just simply one individual who runs a business in their own name. The issue, the downside there is that there's no distinction between the owner and the business. So if the business encounters financial difficulties, the owner personally is on the line for all the debts of the business. The business is, the income of the business forms part of the direct income of the owner, and so is therefore subject to the income tax paid by the owner. It's suitable. The upside of it is that there's very little formality. It doesn't have to be registered with anybody. Obviously, your normal tax registrations, which we'll deal with, but you don't have to register the business with anybody. You don't have the formalities of agreements or partners, or it's just an individual running a business. Then the next less in the next level of formality, if I can call it that, is a joint venture, which is just an agreement between people to carry out a particular project. Now, joint ventures, you can have joint ventures between very large companies, but it's simply an agreement to carry out a project. So you would need to put an agreement in place. Each party brings whatever they've agreed to bring to the party. The agreement will then regulate what they're going to contribute and also how they're going to share in any profits. We'll set out what the purpose of the venture, and then lastly, it'll set out what will happen in the event of a dispute, which would lead to the venture dissolving or the project coming to an end. And the venture having achieved what it was set up to achieve. And the agreement will stipulate then how the assets that have been accumulated will be divided up, how the profits, money in the bank, etc., will be divided up. Again, the partners or the parties to the joint venture contract in their own capacities. So they could be companies, they could be very large companies who just come together to carry out a particular project, or they could be individuals who are just agreed to work on that project together. So it's for a limited purpose, generally won't be for a long-term relationship, but simply to work on one particular venture. The next step up from there is a partnership. that is where the parties have committed themselves to working together as partners, as it says, for an unlimited amount of time and to carry on a business as a partnership. Again, it doesn't have to be registered with anybody. It's regulated by an agreement. The agreement will stipulate what each one will contribute, how each one will share in the profits. It also will have clauses as to if they decide at some point to dissolve the partnership, either because there's a dispute or because one of them wants to move on with their lives. The partners, there's no limited liability as there would be with a company, which we'll discuss next. So the partners are all jointly and severally liable for all the debts incurred by the partnership. So you don't have the benefit of limited liability as you would with a company, but the advantage is that there's less formality. You don't have to, the partners are taxed personally on what they each individually draw from the partnership. The partnership is not taxed separately from them. Then lastly, a company. A company is registered with the CIPC, the Companies Intellectual Property Commission. You have to reserve a name. A company does have limited liability. In other words, the company owns its own assets and incurs its own liabilities separately from the shareholders in the company, or the people who invest in the company. So if you're a shareholder in a company, unless you've signed a suretyship on behalf of the company, you're only liable for, or your risk is only what you've contributed into the company. If the company gets sued, it is the company that is sued. You will not be sued in your personal capacity unless you've committed some fraud or something in the running of the company that, and in those circumstances, the people running the company can be held liable for the company's debts. There's also in a company a division of management and ownership. The company is owned by shareholders and managed by directors. Now, the shareholders and directors can be the same people. In smaller companies, they generally are, but they don't have to be. So the directors can just be employees of the company who don't have a shareholding. So it allows you to bring in parties who are purely investors, who simply own a share with the hope of getting out a profit, but they don't participate in the management. They're purely invested in the company. So that is a summary of the business entities that are used for companies. I may mention, no doubt, many of you here, all of you have heard of closed corporations. Closed corporations, like companies, have limited liability. They were actually abolished by the 2008 Companies Act when it came into force in 2011. CCs that were formed before then still exist and are still allowed to continue, but no new CCs can be formed since the New Companies Act came into effect, or we call it the New Companies Act, but it's already been around for 13 years. So then the next step, once you've agreed on the form of your business, and unless you are a sole proprietor and no one else is involved in the business, it's always advisable, necessary to have some form of founding agreement, whatever you call it, a joint venture agreement, partnership agreement, shareholders agreement in the case of a company. And so that the rules and the arrangements between the participants are set out up front. It's always advisable. No matter how good friends you are, no matter how much trust there is between you, I'm sure a lot of you have experienced that when it comes to money, money can ruin friendships, money can ruin families. It's always a good idea to have some form of founding agreement, like an anti-nuptial contract. As long as you are happy together, things are working together, you'll never look at it, you'll put it away in a file. But if at some point you do have a disagreement, you'll be very grateful that you set out the ground rules up front. So typically what would be included in that agreement would be the contributions that would be put in by each party, whether it's money, whether it's labor, whether it's actual physical assets. Maybe one of them was running a business before and they're going to contribute the assets of that business, and the other person's going to put in money to enable the business to grow. Then management, who's going to be in charge of running the business, who the directors or managers are going to be, and who's going to have which roles in the business. What's going to happen in the event of a disagreement? Who's going to have what votes? Because the last thing you want is to be, if there is a disagreement, to be deadlocked, and then you have to just wind up the business because you can't make any decisions. So it's always important to have terms in your agreement as to how that business is going to be managed and how any disputes are going to be resolved. If one party is going to have more votes than the other, or whether a third party like the auditor of the company or business could be called in to resolve disputes, so that it avoids deadlocks. Then distribution of profits, who's going to get what when profits are made. If, for example, one party has put in more capital than the other, is that party going to get back their capital before the other party becomes entitled to share in the profits? And only after the contributions of the parties have been paid back will they get profits, and in what proportions? Exit provisions, what happens if there is a disagreement? What happens if one party does want to move on and cash in their investment, get into a new business? What happens then? What happens if somebody else comes along and decides that this business has become very valuable and wants to buy into it or wants to take over the whole business? What would happen then, particularly if one party is interested in this offer and another party is not? Typically, what you would have is a situation where if there is an offer for the share of one party and the other party doesn't want to sell, the party who wants to remain in the business has the first option to buy the shares of the exiting party. And if there is an outside offer, it would usually be at an amount equivalent to what the outside offeror is prepared to offer, and on the same terms. If there isn't an outside offer and one of the parties just wants out, then you'll have some sort of mechanism, perhaps again, the auditors or some outside expert who will value the share of the exiting party, and that will become the price at which the remaining party will buy their shares. What you don't necessarily want is that if a party wants to sell their shares, they can just go out and sell them to anyone they like and leave the remaining party saddled with a partner in the business they never anticipated or never wanted to go into business with. Therefore, they have that right of first refusal to buy the exiting party's share. Then general contractual clauses, which are found in virtually all properly drafted legal documents, just definitions of terms so that the agreement is clear to read. What happens if if the parties want to amend the agreement? usually a clause to the effect that if they want to amend the agreement, there has to be a formal written amendment to avoid later disputes and disagreements about what they agreed on, how they agreed to amend it. What would happen if there's a dispute, or if one party breaches the agreement, what mechanisms are going to be used to resolve those disputes? Would it be arbitration, mediation, and so on? Moving on. When you're starting a business, you have to consider your key relationships. You would generally want to tie up relationships with your key stakeholders. So, for example, your suppliers. If you've got a supplier who is supplying your principal raw materials or your most important services, you want to be sure that that party is going to continue to supply you, at a reasonable cost, and therefore you're going to want, and it's recommended that you should have an agreement in place with each of your suppliers, a written agreement that guarantees you that they will supply you at an agreed price for an agreed period, and all of those terms should be tied up. Similarly, with customers, if you've got several big customers who are important to the business, you want to know that they're not going to just drop you overnight. So you'll generally want to come to an arrangement with those people that says, okay, we'll guarantee, in the same way as you want your suppliers to guarantee you supply, you will go to your customers and say, well, we will guarantee you supplies, we'll guarantee you certain standards, quality standards, we'll guarantee you certain fixed prices for a period of time, provided you commit yourself to buying from us in preference to anybody else for as long as we keep to these terms. Therefore, you've got a guaranteed source of income for a specified period of time because you've got your customers tied into those agreements. And having those relationships in place is what gives your business its value. If you at some point want to sell your business, one of the first things that a potential buyer is going to look at is, can you count on your important suppliers? Do you have regular customers who are going to guarantee you a source of income? And all of that will lie in those relationships that you formed and the agreements that you've concluded with those people. Then the landlord, your business premises, for many, many businesses, the landlord and what they spend on the rent of the premises is possibly the single biggest expense, that and salaries. I haven't dealt with employees here because we're going to deal with them in a separate heading. But so you also, important to have a written lease, no matter what type of premises you're in. You don't have to be in a shopping center or a formal office block. It's important to have a written lease. You want to know that your business, as long as you're paying your rent, that your business has a guaranteed place to trade, that you've got guaranteed services, allowing for the service providers who provide water, electricity, and so on, but that the landlord will make sure that as long as his supplies are switched on, yours will be. Then your relationships with financiers and investors. Many startup businesses have to rely on finance from the bank, from So from other finance houses, from investors, people who are just putting in money, as we mentioned earlier, for shares in the business in the expectation of perhaps getting a return on investment. They have shares rather than a loan, but those terms should also be very clearly decided. Just to take, even if it is an informal, based on a friendly relationship, somebody puts in money into your business, somebody lends you money to start your business, those relationships need to be clearly tied up, because the last thing you want, if it's not, is that your financier comes to you out of the blue and says, now I gave you R1 million, I want my money back. And you're not in a position to pay it back. You need to know where you stand. In moving on with the next of all the compliance requirements, every business has to be registered for certain taxes. Firstly, income tax. As we mentioned, as if you're a sole proprietor, if you're a partnership, the partners or the proprietor pays income tax on what they receive out of the business. The business is not taxed separately from them. So the business's income is their income. The other side of that is obviously the business's expenses are their expenses and can be written against whatever income tax they have to pay. Then if you have employees, as soon as you are paying people salaries, your employees have to be registered for PAYE, and you as an employer are responsible for paying over PAYE that you deduct from your employees each month or week or however regularly they get paid. And then you as the employer are responsible, you're registered with SARS for paying the PAYE, and you have to pay it over. Unemployment insurance fund, it's compulsory to pay in a small percentage, I think it's 1% of your income that you pay on based on each employee's salary, plus 1% that's deducted from their own income, gets paid into the unemployment insurance fund. And again, as an employer, you are responsible for paying your contribution, collecting the employee's contribution, paying it over to the unemployment insurance fund. Then the skills development levy. If you have a certain number of employees, you're required to pay the skills development levy into the Department of Labor. You have to be registered for that. Lastly, VAT. VAT has to be charged on all supplies of goods and services. If your turnover is not less than R1 million a year, if your turnover is less than R1 million a year, you don't have to be registered for VAT. As soon as it hits that level, you need to register for VAT. Then the next thing to look at is employment. In terms of the Labor Relations Act, Basic Conditions of Employment Act, there are certain minimum standards that you have to comply with. Firstly, every employee at whatever level has to have a written employment contract. You cannot just simply employ someone informally without a contract. And so everyone, and that employment contract has to set out their job description, has to set out their working hours, has to set out their remuneration, other benefits such as leave, sick leave, family responsibility leave. They are all requirements in terms of the legislation, and that will vary according to the type of employee, whether they, in what industry they're in. In some industries, people cannot be compelled to work more than 5 days a week, and some not more than 6 days a week. People who work night shifts can't be compelled to work more than a certain number of night shifts in a particular period of time. People who, and so on. Provisions for overtime need to be included in that agreement. If they're going to work more than a certain number, work outside their normal hours, they have to be paid overtime, and that has to be catered for. Then this very vexed question of termination and retrenchment, which is seen as problematic by most, if not, well, many, if not most, small business owners. Our employment law was not designed for a developing economy. It was designed for an economy with a 5 or at most 8% unemployment rate, where employees and where the labor market is not as flexible as it is here, and where employees have a lot more power because there isn't a large pool of unemployed people from whom businesses can employ people. It's just a result of the history of this country, where the trade unions became very powerful as part of the liberation struggle, and therefore they had a big say in the drafting of the labor legislation, and in particular legislation around termination and retrenchment. So employees cannot simply be asked to leave. What you see in the movies where somebody just turns around and tells someone they're fired, that doesn't work that way. An employee who commits some type of offense, even a most serious offense, needs to be disciplined. They have to go through a disciplinary process, even in the smallest of businesses, where they are given the opportunity of stating their case. They are formally charged, and only once they are found guilty can they be dismissed. And even then, you can't necessarily dismiss someone for an offense that's not of a really serious nature. Similarly with retrenchments, if the business is restructuring, perhaps you need to cut down on the number of employees, there's a process that has to be followed. So that process, you have to consult with the employees. You have to follow a process, as they call it, of first in, first out. So you cannot pick and choose. If you're retrenching, you cannot pick and choose which employees you're going to retrench. So, well, I like John more than I like Mary. I'm going to retrench Mary, not John. If Mary's been in the business longer than John, she has the prior right. You then have to consult with both of them, give them the opportunity of stating why they should not be retrenched based on the fact that they perhaps bring skills to the business that the other one doesn't. You have to offer alternatives, offer alternative employment if that exists within the business. And you have to follow that process to show that you've done everything reasonable to avoid people losing jobs. Moving on from employment, the next issue that businesses need to be concerned about is intellectual property. So intellectual property is one of the most valuable assets that a business can have. Intellectual property is really anything that is the creation of somebody's mind, that while it can be depicted physically, doesn't have a physical existence. It's a product of thought. It's a product of inventiveness. And these are very valuable assets. In fact, for most businesses, outside of businesses that own huge real estate, their intellectual property is their biggest asset. At one stage, I don't know if it still is the case, the Coca-Cola trademark was the single most valuable asset other than real estate in the world. I think it then became the Microsoft trademark. And I don't know which, maybe today it's Amazon. I don't, but intellectual property is very valuable. And for that reason, if your business has intellectual property, it's very important to protect it. Now, intellectual property falls into various categories. The first one is trademarks. Now, trademarks are any badge that you use, and I use the term badge in a very wide sense, to distinguish your business or your products. So it can be simply a name, it can be a logo, a symbol, as long as it is something that is distinctive to your business. So, and that distinguishes your business from anybody else's. So if you think the McDonald's golden M, if you think the Coca-Cola trademarks, now there, for example, that's a nice example where, for example, the name Coca-Cola is a valuable trademark in itself, but then you've also got what they call that ribbon script, that very distinctive way of writing the Coca-Cola name that it appears on the cans and other Coca-Cola products, where based on that wavy script, Coca-Cola is distinguished. So you can actually write another name in that script in red on a white background or in black on a red background, and it will be identified with Coca-Cola, even if it doesn't actually say Coca-Cola. So therefore, then a company like Coca-Cola will have gone and registered that mark as a trademark. The trademark doesn't have to be registered to be valid, but it just makes life a whole lot easier if you've got proof of registration in your name, because otherwise you have to, if somebody does copy your trademark or use your trademark without permission, you've got to actually prove that you have a greater right to it than them by showing that by the market, whoever the market happens to be for that particular product, identifies that trademark with you rather than with them. So it's advisable to register that trademark. Then all you have to do is pull out that registration certificate, and the onus then shifts to the other party to prove that they have a greater right than you. The next category of intellectual property is trade secrets. So now, trade secrets consists of anything that you have within your business that you consider to be an asset that you would not want to get into the hands of your competitors. So, for example, the prices and how you calculate the prices of your products. If you're running a restaurant, perhaps your recipes. If you have special deals with your suppliers and can get a product cheaper based on these special deals, that would be confidential information. You have specific sales methods and secret formulae. All of these sort of things are your trade secrets. Now, those can't be registered. So to protect them, you as a business owner have to be careful to keep them confidential within the business. So what you would do is, firstly, make sure that no one who doesn't need to have access to them has access to them. Secondly, anybody who does have access to them, any of your employees who works with them, who becomes aware of them, has to sign a non-disclosure agreement in terms of which they agree that that particular information, whatever it happens to be, is confidential and is a secret asset of the business, and undertakes not to disclose it either while they are employed by you or after they were employed by you, for as long as it actually is not known in public. Many businesses actually get their employees to sign restraints of trade, where they undertake not to work for a competitor for a certain period of time after they have left the business. And that is to protect those trade secrets and confidential information. So your employer will make sure that you, for a period of time, so let's, for example, say that during the time you're employed, the company develops, it keeps updating its prices, it enters into new deals with suppliers, it develops new products, but it does this maybe once a year. It updates its prices, or its suppliers update their prices. Then you would work out how long will it take for the information that an employee has after they leave the company to become outdated and to become of no commercial value. And you might then impose a restraint of trade on them and get them to undertake not to take up employment with a competitor for as long as that information has commercial value. The next category of intellectual property is patents. Now, patents are scientific inventions, any way of doing something that can be made into a product, whether it's an engineering product, a machine, something of that nature, whether it's a chemical formula that can be used to formulate a pharmaceutical product. Those are all potentially subjects of patents. A patent can be registered and is valid, depending on the country, for a period of normally around 20-25 years. And during that time, nobody can replicate the invention. So for that period of time, you have to capitalize on it to recover what you put in research and development, and make a profit out of your invention. Copyright then, excuse me, relates to works that any original work, as soon as it's created, enjoys copyright. The creator enjoys copyright in that work. So that can extend to what artwork, literary works, computer programs, musical work. And as soon as the only requirement is that it's original. And as soon as it's original, then the creator owns copyright and can prevent other people from copying it without their permission. Just when you talk about literary works, artworks, the term is very loose. It doesn't have to be Picasso, Shakespeare, or Beethoven. A list, like a telephone directory, would be a literary work as long as it is the product of someone's original thought. An advertising jingle, all of these enjoy copyright and can be protected. If you are an employer, it's quite important to make sure that your employees understand and agree in their employment contracts that if they develop anything that is subject to copyright, and they are paid for it as part of their employment, that it vests in the company. A lot of people get caught out, and also if you engage an outside contractor, that outside, to create something for you, to create a design, a logo, anything, if you've engaged to write a computer program for you, the outside contractor is the creator. So they own the copyright. Many people get caught, fall into this trap of believing that if they have paid somebody to create that work, that they then own the copyright and they can do with it as they please. That's not the case. They can only use it for the purposes of whatever that agreement was. So if the person's saying, I'm creating an ad campaign for you, you can use this ad campaign purely for this purpose, for this particular period of time. But you then can't go and take my artwork that I developed for this ad campaign, give it to another agency, and let them use it in another ad campaign. If you want to do that, you have to, in your agreement with your original designer, make sure that they've agreed that the copyright is assigned to you. In other words, that you now become the owner of the copyright. The last category is designs. A design is any three-dimensional, it doesn't have to be three-dimensional, but it has to then be capable of being turned into a three-dimensional product. So you'll be talking about the shape of a bottle, the shape of a vase, a table, anything of that nature. There'll be copyright in the design, but then once it becomes a three-dimensional product, then you can register a design in respect of that product. So for example, again, going back to the Coca-Cola example, we all know that for years, Coca-Cola made those bottles with the hourglass shaped bottles, and those were registered as designs because they were distinctive to Coca-Cola. Now, there are two types of designs. One is the purely aesthetic design, where it's just a look, an artistic look, such as the hourglass bottle. And then there are other designs where the shape and the design of the product is functional, that it's the shape of it affects the way it operates. So again, in terms of certain packaging, those square boxes that you get milk in, for example, those that would, the designs of those are functional designs based on the function they form, because they are easier to pack that way, and they are easier to stack, they're easier to transport. Then the last topic that we're going to cover as part of the formal presentation is data protection. It's one that concerns a lot of businesses. It's very misunderstood, and therefore it is something that business owners need to be aware of, because knowledge and information is possibly the currency of the modern economy, more so than machines, more so than materials. We deal in information, and every business receives information, and as soon as you do receive information, there are obligations on you to deal with that information in accordance with the law and in accordance with the rights of the person to whom that information belongs. So what's protected here? It's it falls under the Protection of Personal Information Act, which people refer to as POPI or POPIA, and it protects personal information. Now, personal information is any information that can be linked to an individual, or in circumstances, if it is appropriate, to a company. So that not only that person's name, their ID number, their address, their physical characteristics, their state of health, the details of their employment, details of their financial situation, their religion, their political beliefs, any information that can be linked to an identifiable person is personal information, and that person's entitled to expect it to be protected as soon as they give that information to anybody else. And that means that it can only be used for the purpose for which it was given. And when that information is collected, if you are a person receiving information, and say virtually every business does, because you're going to receive information related to your customers, you're going to receive information related to people that you do business with, and you have to stipulate the purpose for which you're collecting that information. So if you are opening an account for a customer, you are entitled to ask for the type of information you would need to open their account, which would be their name, possibly get trading references on them, their ID number, their bank account details. But you have to stipulate that this is for the purpose of opening an account in our books, for obtaining credit references on you, for communicating with you in regard to new products, regard to services we provide. And for that reason, we need this information. And then the onus is on you to make sure that you do only use it for that information. Now, the Act talks about the use of information as being processing. And the Act defines processing very widely. So it ranges from the initial collection of the information, the purpose for which it is used, the storage of information. So if you're keeping it in a computer, you have to make sure that computer is secure and the information cannot be hacked out of it. Then if it is passed on to other people, so for example, if you are manufacturing, if you manufacturing a product for somebody, and you have to go to somebody who's supplying or maybe making one particular part of that product, and you have to say, well, I need it to be this size because if you say it's a medical device of some kind, a prosthetic, needs to be this size, it needs to be for a person who suffers from a particular type of disability, whatever it is. If you're going to be giving that information, any of that information, to a third party, you have to make sure that the third party also gives undertakings to maintain the confidentiality of that information. So the primary conditions are knowledge and consent on the part of the the data subject, as it's called, the limitation on the use only for the purpose for which it's collected, and then lastly, in terms of storage, you are allowed to store it only for as long as you need it. Once you no longer need that information, when you finish doing business with that person, or when that information becomes outdated because the person's passed away, the person is no longer needs the product, whatever it is, you have to destroy it. There are certain exemptions, which is for in the public sector, it would be where a government state body requires to use that information to fulfill its functions. So, for example, if the police need to find out personal information in order to arrest somebody, carry out their duties, if and so on, then they're entitled to that information if the prosecuting authorities need that information. For private individuals and private organizations, the primary exemption is if you can justify that you need that information to assert a right of your own. So, for example, if you are involved in litigation and you need information as evidence, and you can use that provided you inform the owner that you are using it for that purpose. So that's just a very brief breakdown of what I thought would be the real main aspects of what a business owner would, particularly someone starting up a new business, but would want to know, and the things they should be aware of. We've got some time for questions, so I can open it up if there are questions.
Thank you, Ian. There are a couple of questions in our chat box.
Okay, I'm just looking for the chat box.
Yes, I think if you close your presentation, but Adrian has asked, is there a minimum turnover required before you can fully register for voluntary VAT?
Sorry, you said, is there a
minimum turnover required before you can register for VAT?
There's no minimum before you can, but there's a minimum before you have to, which is R1 million in 12 months.
Thank you. And Adrian, are you fine with that? I see your response. Thank you. We also have a question from Philip. He said, in terms of partnerships and employment agreements, how does one include non-disclosures, as for example in the food industry, where both the recipes and processes may be very unique to your business?
Yes, well then you would get everybody who's going to obtain knowledge of those to sign a non-disclosure agreement. So that would be something that would either be in the employment contract or the partnership agreement, or a separate document to say, I agree and undertake that these particular things are confidential, whatever they happen to be, whether it's recipes, whether it's financial information, other product information. And I undertake that for as long as this is not in the public domain, in other words, that it didn't get out into the public through another source, I will not disclose it to anybody. Does that answer the question?
Thank you.
Philip, I see you put another question. Would you like to ask Ian?
Okay, I've got the chat so I can read it. For business contracts, it's so as I understand this, Philip, but please correct me if I'm misunderstanding. You're saying, can you, in your if you are contracting with A who provides a service to B?
Yes, and B's not a main producer of anything at all. They're only providing a service to a third company or a fourth company who actually do the manufacturing, but you as a contractor are servicing the B. Whereas,
yes, well,
do you have let me rephrase it. Do you have a right to a separate contract with with their manufacturer, or can you have a comprehensive contract that would include both sides?
Yes, you can do that. I mean, sometimes.
What's the better option?
Well, if all the parties are involved in the same process, possibly better to have all the parties involved in one relationship and in one agreement.
Right.
So in terms of, is there a legal entitlement? Well, there's a legal entitlement to anything that you can negotiate. So if you, if everybody or both parties concerned are happy that they're receiving value, they should be happy to make a payment for it, as long as if they see that the payment is related to the value they're receiving.
Okay, thank you. Just one last question, and I've just thought of it now. What is the legal status of an ad hoc agreement where there's nothing actually written down? Everything is verbal, and it goes literally from day to day, from hour to hour.
Okay, there's nothing not legal. I mean, there's certain contracts like sales of land and credit agreements in where you're buying goods on credit, or you're receiving credit from a financial institution, that by law have to be in writing.
Right.
And franchise agreements, for example. But in general, an oral or verbal agreement is completely binding. The only problem about an oral or verbal agreement is that a year or two down the line, both parties possibly have a very different idea about what was discussed when the agreement was first entered into. And so that's why it's advisable to have it in writing, because and with their signatures on it, because then they can't deny it.
Yeah, your word and my word.
yes, I mean, as I don't know if he actually said it, but according to the urban legend, Sam Goldwyn, the movie producer, said a verbal contract is not worth the paper it's written on.
Mm. Exactly. Thank you very much for an interesting webinar. Thank you.
Sure. Just for everybody, before we sign off, please, there is a feedback poll. If you could please give us your feedback. And then there's also a donation poll. Your assistance, obviously, 𝐓𝐡𝐞 is doing great work for the business community. And if people can make contributions to keep this work going, that would be really appreciated.
Thank you so much, Ian, and thank you for closing off for us today so beautifully. We really appreciate you giving up your lunchtime power hour to share all your expertise with us. And also thank you for being available always to assist 𝐓𝐡𝐞 very specifically with things that we need read and signed and sealed. So thank you for that.
Well,
for our members,
always my pleasure.
Thank you, Ian. For our members who are online today, please don't forget we have a business boot camp tomorrow morning at 9 a.m. with Laurie Milner on personal branding. And on Thursday, we have another business boot camp on cybersecurity with Peter Botha. Also, a new module for our business bootcamp series. So please, if it is of interest to you, ensure to register and to join us. Ian, thank you so very much.
Thank you, everybody.
On behalf of myself, Helene, who's been listening in, and everyone else, we thank you for your time. We appreciate the work that you do and the help that you give us. And we wish everyone a lovely afternoon.
Thank you. Bye, everybody.
Bye, Ian. Thank you.